Good day, Crime Talk aficionados. We have a great show for you today. First, the gruesome crime scene photos in the Bryan Kohberger case. Are they going to be released? The singer who spells his name David with a 4, well, he lawyers up. Luigi Mangione, his court appearance has been canceled because he demands to appear in person. We have this day in legal history, our legal quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And remember, you can check us out anytime on any of your favorite podcasting apps. So this is our last show from Milan. Well, I guess Italy, technically. We were in Lake Como for my son's wedding and his my daughter-in-law. It was absolutely amazing wedding, amazing location. It was absolutely perfect in every way possible. Friends, family were all there, so it was very, very nice indeed. But we are back in Milan today because we catch a flight first thing early morning back to Denver. So next week, we'll be in the Crime Talk studios. Sorry for missing a couple of days, but had a couple of other important things to focus upon, if you know what I mean. All right, before we get to the docket, let me remind you to go to crimetalksearch.com. When you go there, you can sign up for a background subscription. Okay, this is what professionals use. We use it in the law practice every day. We find stuff out about people that sometimes doesn't even pop up when we hire the professional investigator to track somebody down. When you go there, you'll find emails that are associated with an individual, their social media presence, phone numbers, criminal history, addresses, property that they own. Are they hiding assets from you? Everything you want to know about somebody, you're going to find in that report that is literally emailed to you while you wait, and you can get updates when the information changes. And remember, you can cancel the subscription at any time. So whether you want to do one search or you want to do hundreds of searches because you're interested in a case that we're following, go check everybody out. Go check out all the players. Guess what? Heck, you could even have the breaking news on a big case. You just never know. So go to crimetalksearch.com. You're going to be happy that you did. And also you can go to the merch store in the link below. We kind of let the merch stuff, we didn't focus on it much lately, but we're going to get back into it. So go check it out. We've got a lot of new things coming your way. So please do that. All right, let's go ahead and open the record for Friday, October 3rd, 2025. Now, we're actually filming this early morning in Denver time. It's late afternoon in Italy, and the Sean P. Diddy Combs sentencing hearing has not started, but we'll talk about it on Monday. Now, for those who don't recall, Sean Diddy Combs was charged with a lot of serious offenses, but he was only acquitted of a couple of counts of basically transporting prostitutes across state line. Not the most serious offense, clearly illegal though. And so the question is, what will the judge do? Now remember, the federal sentencing guidelines are a starting point, one factor the court must consider, but they have to look at all of the factors associated with sentencing: punishment, deterrence, rehabilitation, protection of society under 18 United States Code 3553A. All those factors that the court needs to decide. The defense, Sean Combs, he wants basically credit time served, and hey, this has been 2 of the most difficult years of my life. Prosecution says, no, judge. He's really not, hasn't really accepted responsibility. He was found guilty, made the prosecution go to trial, proved the case beyond a reasonable doubt, and he was acquitted of the most serious charges. But the prosecution still wants 11 years. Obviously, if Sean Combs is my client, I'd be arguing his position, credit time served, or a sentence in between. Then, obviously, the prosecution wants to have the 11-year sentence. Hey, that's what you do as a prosecutor. The question is, what will the judge do? Now, the judge, who's had lots of opportunities to bond him out of custody, or allow him to bond out of custody, I should say more eloquently, has denied that opportunity to do so, because he feels he's basically still a danger to the community. There's a lot of stuff that the judge, shouldn't take into consideration because Sean Combs was found not guilty of it. But the reality of it is Sean Combs was living kind of a gangster lifestyle on the edge, and he had a lot of money and people helping protect him. So what's the prediction? I think the judge splits the baby. Doesn't give him credit time served, and we'll see. And I don't think it gives them the maximum 11 year. I think the judge splits the baby, probably goes, 5 years. It's not the maximum. It's not there. It's right down the middle. Yes, splitting the proverbial baby. All right, next on the docket, let's talk about Bryan Kohberger and whether those gruesome photos will be released. The answer is no. So although not all of the plaintiff's demands were met, Judge Marshall determined that the profound psychological trauma resulting from the ongoing dissemination of images showing the victim's remains and crime scene surpassed the public's legitimate interest in scrutinizing the investigative process. So, as you may recall, several family members sued the police department saying, we want an injunction saying you cannot release these crime scene photos because it's going to be so traumatizing to us to come across those on the internet. We don't want them. The judge rules basically in their favor. The ruling asserts that the general public derives minimal benefit from viewing representations of the deceased individual's bodies, blood-saturated bedding, spatter patterns, or other elements of the fatality's locations. Furthermore, the judgment indicates that the mere obscuring of specific details falls short as it continues to reveal the shapes and forms of the victims' bodies. Consequently, the city of Moscow, Idaho, there is obligated to completely redact any segment in images, photographs, videos, or other materials that portray any part of the victims or their bodies, along with adjacent bloodstains. Now, the city of Moscow maintains that Idaho statutes compels it to disclose these materials. Nevertheless, the order finds that the city inflicted irreversible damage on the plaintiffs by previously distributing obscured depictions of the homicide victims, thereby justifying the provisions of the remedies of the affected parties. Now, I had been and will always continue to be, I think that the public has a right to know. And I think that these photographs ought to be made available, and not for some form of gratification or sensationalism, but rather to illuminate at the nature of the violence and to demonstrate the capacity of individuals to perpetrate atrocities against others, fostering, a greater awareness and maybe a little prevention of such acts in the future. And what I mean by that, ladies and gentlemen, is people need to see that evil exists in the world. There's nothing basically salacious about that. It's not to try to be gross about it. I appreciate it. I would not imagine. I'm sure if maybe my kids, I'd have a different opinion about that. But the reality of it is, I think if that were my kids and somebody had done that to them, I don't want to show the world to say Bryan Kohberger is a horrible person. Look at what he did. And maybe he should have got the death penalty. And one of the reasons why I truly believe that Bryan Kohberger took the plea for life without the possibility of parole was the fact that he knew when the jury saw those photographs and what he did to those young individuals that he knew he was going to get the death penalty. Ladies and gentlemen, like I said, it can be done in a respectable way, redacting things of that nature, but this blood splatter does matter so that people know the brutality that took place in that house that night. And for people to know that this is what other human beings are capable of. And if this is what they did, maybe they don't deserve to ever walk among us or even to, reside in the same state with us. Something to think about. Let me know in the comments what you think. Did the judge make the right decision? Do you think they should be disclosed? I think it can be done somewhat respectful to the families. It can be done tastefully. But the reality of it is, I think the public has a right to know. Maybe these things are so brutal, everyone was, oh my gosh, he should have got the death penalty. Or, oh, it was nothing. But when we're talking about the brutality that we know about, the 52 stab wounds in one victim, her face basically dismembered, we need to know what people are capable of. And Bryan Kohberger probably should have got the ultimate punishment, ladies and gentlemen. And he gave up that presumption of innocence when he pled guilty. Next on the docket, that singer who spells his name David with a 4. Well, he engaged a high-profile criminal defense attorney. That's right. The musician David, whose full name is David Anthony Burke, and who is 20 years old, has hired the services of Blair Burke, a criminal lawyer with a history of representing some high-profile figures such as Harvey Weinstein, Lindsay Lohan, Kanye West, Mel Gibson, Britney Spears, and Bruno Mars. Now, this development occurs as law enforcement continue to examine these, unusual circumstances surrounding the dismembered body of a 14-year-old woman by the name of Celeste Rivas Hernandez, who was found in the trunk of Burke's abandoned Tesla. The vehicle was ultimately towed to a storage facility in Hollywood, where the remains were discovered on September 8th. Now, Burke has not been designated as a suspect in this disturbing set of circumstances. And Burke, his newly appointed counsel, has a notable track record that includes defending Weinstein, the former film producer, currently incarcerated for the convictions related to sexual offenses, obviously. With over 2 million followers on his Instagram, Burke has refrained from making public statements regarding the investigation, aside from asserting by his representation that he is fully cooperating with the police. Now, the adolescent's remains were identified one day following what would have been her 15th birthday, and officials have indicated that she had been deceased for multiple weeks prior to the discovery, confirming her age as 14 at the time of her death. Now, the Tesla had received a parking citation for almost 2 weeks before the body was found, and investigators are still trying to determine the precise timeline of the girl's death and the duration her remains were present in the car. So yeah, obviously, this young man has some problems. It's his car. Why is your girlfriend dismembered in the front trunk of your Tesla? Yes, those are questions that inquiring minds want to know. Now, certainly he's entitled to the presumption of innocence. Who knows? Maybe she, did something horrible, dismembered herself, threw herself in that car all by herself. No, that's ridiculous, right? That didn't happen. Somebody familiar, close to David with a 4, had some involvement, and I would think him and his associates should all be lawyering up as well. And although this young man has only received some recent fame, guess what? He is going to spend every penny that he has earned this point on good legal representation. And at the end of it, win, lose, or draw, who knows, maybe he'll never even be charged. He'll be saying it was a good thing to lawyer up early. Next in the docket, Luigi Mangione. They canceled his court because he wants to be there. That's right. So the scheduled pretrial hearing for Luigi Mangione there in Blair County, Pennsylvania, set for November 7th, has been canceled following a motion that emphasized the necessity of his physical attendance. Now, Mangione, arrested there in Altoona, Pennsylvania in December and subsequently transferred to New York for trial related to the fatal shooting of healthcare executive Bryan Thompson in Manhattan, retains the option to join the Blair County proceedings via remote means. In Blair County, he's charged with offenses including forgery, unlawful possession of a firearm, tampering with records, and some other sundry of charges. However, Judge Jackie Bernard has determined that Mangione is unavailable for the November 7th session, citing his stated preference to attend all court matters in person, which certainly he has a right to do. A criminal defendant has the right to attend and should attend every critical stage of the proceedings. Certainly that's arraignment, motions, trial, obviously, but it really includes even continuances, because if you have to waive speedy trial or something along those lines, I'm basically of the mindset that nothing gets done unless the client is there. And if they want to appear via video, they must consent to that. Now, most people in custody don't like the disruption of going from one facility to another, but that's certainly his right to be there. Now, this ruling responded to a motion submitted by the defense counsel, a guy by the name of Thomas Dickey, on behalf of Mr. Mangione. In recent communications, Dickey has consented assertions from the Blair County District Attorney's Office, which indicated that logistical concerns such as security and cost preclude Mangione's transport to the county, while proposing remote involvement as a viable alternative. Now, in his latest submission, though, Dickey criticized the prosecution for not furnishing adequate evidence of Mangione's transport unavailability, noting that the provided materials originated from a data analyst in the United States Attorney's Office for the Southern District of New York, and they were deemed to be inadequate. So to address Dickey's call for a hearing on the documentation shortfall, Judge Bernard issued an order on Monday directing prosecutors to provide a formal writ from an appropriate federal entity within 30 days, confirming Mangione's inability to appear in Blair County. In a subsequent section of the order, the judge officially postponed the November 7th hearing, during which Dickey intended to contest the validity of Mangione's arrest in Altoona. Now, Blair County District Attorney Pete Weeks and First Assistant District Attorney Nicole Smith have maintained that the arrest complied with the legal standards. And so obviously the judge will need to decide the motion to suppress issue. Where's there reasonable suspicion, probable cause to arrest, were any searches done illegally, resulting in potentially the suppression of any of that evidence. Now, certainly Mr. Mangione has the absolute right to be there, and frankly, he should be. Now, but when you're dealing from somebody that's in federal custody and the state wants them, well, the state, you just don't call the feds up and say, we need somebody here. The feds are very protective of their inmates, and they like to keep them there. And so you have to prepare what is referred to as the 11-point memorandum, which basically says, you know, who do you want? Where do you want to take them? How are they going to get there? And how are they going to return? It's basically a motion for permission to travel from the feds. It's a lot of paperwork for the state prosecutors, but it's not impossible. And hey, you know, security, travel expenses, well, that's part of the justice system. And a little inconvenience, you know, Mr. Mangione is clearly inconvenienced because he's in custody, being held without any bond. The least the prosecution can do is to pay for his travel to get him there to the court appearance. So anyway, the judge supported her canceling order by referencing segments of Dickey's motions, which affirmed Mangione's insistence on personal presence at all key procedural stages, which clearly a motions hearing is. You want your client there. Something comes up. What if your client is needed to testify? Very difficult to do that if he's appearing via WebEx. The order, however, further notes that the issue may be reexamined upon receipt of the required documentation from the prosecutors or in the event of noncompliance. Additionally, reconsideration is possible should Mangione opt for remote participation in future Blair County matters. I wouldn't. Luigi, I'm not a big fan of yours. I don't think you have a whole lot of viable defenses, but I appreciate your desire to be there at the critical stage of the proceedings. And by God, the prosecution should bring you there. Regardless of cost, regardless of security, justice is expensive. Tell that to the county commissioners and get some more money, Mr. Prosecutor. Next, this day in legal history, October 3rd, 1951, the United States Supreme Court decides in Dennis v. United States, upholding convictions under the Smith Act for advocating overthrow of the government, establishing the clear and present danger test for free speech limits during the Cold War. There you go. Can't go saying you want to overthrow the government, ladies and gentlemen. Now, obviously, that's been pared back a little bit, but the reality is, you know, it's still a crime to plot to overthrow the government. This date, 1957, President Dwight D. Eisenhower signs the Civil Rights Act of 1957, and that was the first federal civil rights legislation since Reconstruction, creating the United States Commission on Civil Rights and strengthening voting rights enforcement under the 15th Amendment. On October 3rd, 1965, the United States Supreme Court in Pointer v. Texas rules that states must provide the right to confront witnesses in criminal trials, extending once again the Sixth Amendment protections to state courts via the 14th Amendment and its due process clause. Remember, ladies and gentlemen, the Bill of Rights applied for federal trials, federal government, limitations on the federal government. And over the years, the Supreme Court has decided what is also required by the states. Remember, the states could give you greater protection than the Bill of Rights. They couldn't necessarily limit to them, but they didn't necessarily have to make them apply. But here they said, nope, you have a right to confront and cross-examine all witnesses. So you can't just put in a piece of paper and say, well, this is what they wrote down. They got to bring him to court to be subject to cross-examination. The greatest truth-seeking tool ever created, ladies and gentlemen. And on this date, October 3rd, 1967, the United States Supreme Court in Katz v. United States holds that warrantless electronic surveillance violates the Fourth Amendment, expanding privacy rights beyond the physical intrusion and redefining searches. That was a wiretaps case, ladies and gentlemen. Yes, the federal government cannot listen in on your phone unless they have a warrant. And it's so amazing these days. Now they just get a warrant. They send it over because they're never turned down. They're never turned down. You can look it up. There's like a 99.99999% of federal warrants for wiretaps that are granted. And literally, once they have your phone under a wiretap, they literally, when you start dialing, boop, 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 the little numbers, they hear that. If it goes to a voicemail, they record that. It's amazing what people say in criminal activities on their voicemail, let alone it includes text messages as well. So be careful, my friends. Be careful. And on this date, October 3rd, 1995, O.J. Simpson is acquitted in the criminal trial for the murders of Nicole Brown Simpson and Ron Goldman, highlighting racial disparities in the justice system and obviously media influence on trials, and obviously brought around some reforms in evidence handling. And yes, just like Karen Reed, who was going to be out there searching for the real killer, O.J. Simpson started looking for the real killer of Nicole Brown Simpson and Ron Goldman on every golf course in Florida, where his estate was not subject to that huge civil judgment. So I think Karen Reed may be relocating down there as well too someday. We'll wait and see. I know the Karen Reed crowd is going to hate that, but hey, so let's lower standard. Let's just put it that way. And finally, our quote of the day. Let's talk about a quote regarding confessions. United States Supreme Court majority opinion in Miranda v. Arizona, ladies and gentlemen. So prior to questioning, this is the 1966. Remember, everybody can recite this, but prior to this decision in 1966, which was completely made up, the United States Supreme Court said in Miranda v. Arizona, quote, prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. Obviously, this underscores the procedural safeguards required to protect against compelled self-incrimination under the Fifth Amendment to the United States. Hence, modern-day Miranda advisement. It's completely judge-made. They made it up. And the Supreme Court said, listen, sometimes those criminals aren't the smartest people. All right? And we're going to give them a little bit of a safety net here. We're going to tell them, hey, before I want to know anything about what we think you did, we're going to advise you of these Miranda rights. Now, it's only if you're in custody. Remember that, in custody. And when you're being interrogated about what you're a suspect in, okay? I get calls all the time. Well, they didn't read my Miranda rights. Well, did they question you when they arrested you? No, they just came and arrested me. Well, they didn't need to read you your Miranda rights. It's in custody and questioning, ladies and gentlemen. Remember that, okay? But Supreme Court said, hey, everyone's not the sharpest tool in the shed here that's committing crime, but we're going to help them out. We're going to try to help them out. We're going to say hint, hint, wink, wink, nudge, nudge, say no more, say no more. Literally, say no more, lawyer up, and yet most people don't. They yak. They want to know what went on, what's going on. I had clients say, well, I didn't talk. They tell me, I didn't talk to the cops. Really? Okay. Maybe I talked to them, just couldn't find out what was going on. Oh, did you push yourself in a state of crime? Well, yeah, maybe, but I didn't admit to anything. Okay, well, how long did this not having a conversation with the cop take place? Probably no more than an hour. And at that time, the client has just screwed himself. And frankly, you deserve it, because if you're not smart enough to follow the warning from the United States Supreme Court not to talk, well, you probably deserve what you get. And then our dumb criminal of the day. Yes, how utterly brilliant. Just moments after unleashing his inner artist on 17 unsuspecting vehicles in a Missouri University parking area, a 19-year-old second-year student decided to engage in a profound intellectual exchange with ChatGPT. In this enlightening dialogue, he graciously admitted to the deed, pondered the slim chances of detection, and even inquired if there was any conceivable method by which authorities might pinpoint him as the culprit, as detailed in the arrest affidavit. Enter our dumb criminal of the day, Ryan Schaefer, who found himself apprehended the following day on charges of serious property destruction for his pre-dawn escapade at the Missouri State University parking lot. Police claim he masterfully demolished windows, detached mirrors, inflicted craters on hoods, and snapped wipers during his 3 a.m. masterpiece escapade. When presented with crystal clear video evidence and assorted proofs, Mr. Schaefer astutely observed a striking similarity between the perpetrator and his own reflection. Naturally, he then volunteered his smartphone for inspection. Of course you did. You know they'd have to get a warrant for that. You know that, sir. Right? Right, Mr. Schaefer? You knew that. We just talked about it. Cats. Miranda. Anyway, a thorough examination, consent was given, of the phone uncovered geolocation records conveniently situating him right at the offense location alongside a rather disturbing back and forth with the AI application on his device, as noted by the prosecution. The damning ChatGPT session, replete with charming spelling errors, kicked off with Schaefer's eloquent queries like, "How doomed am I? And might I end up incarcerated?" Following the AI's sage advice on the repercussions of such antics, he thoughtfully added, "Suppose I obliterated numerous automobiles." As the conversation escalated into a veritable meltdown, investigators report, Schaefer turned hostile towards the chatbot, declaring, "I shall eliminate every last one of you imbeciles." Well, back in his Springfield residence, he apparently calmed somewhat and boasted, "I evaded consequences previously, and I doubt they could identify me." He further reflected, "It was quite satisfying to wreck their possessions." Admitting he had thoroughly vandalized those pointless individuals' vehicles, Schaefer opined that the owners all merit the most heinous violations imaginable. Well, Mr. Schaefer remained detained pending a $7,500 bond that he was unable to make, but should he secure release, he will be prohibited from establishments primarily vending intoxicants and must submit to sporadic substance abuse screenings. Additionally, the scholarly figure will be equipped with a satellite tracking ankle monitor for good measure. Mr. Schaefer, you are a dumb criminal of the day. Don't turn over your phone for inspection. Make him get a warrant. All right. Cats, don't forget Carpenter. Very more recent Supreme Court case on that. And Miranda, keep your mouth shut. Sure, they would have had the video look just like you, but you could just deny that, right? Doubt it. Anyway, Mr. Schaefer, you are a dumb criminal of the day, and I bet you get expelled from school. Congratulations. You made it. All right, ladies and gentlemen, that's all we have for you today. Once again, it's our last show from Italy. We'll see you next week when we're back in the Crime Talk studios. But remember, the Constitution matters.